Yes.
Let's go ahead and get started this morning. Let me read, excuse me, Mike.
You just
Nope.
muted. There you go.
Is that one? No?
There you go.
That's it? Okay. I've got a statement I need to get read into the record for this morning. Today's date is Wednesday, May the 29th, and this is a special called meeting of the Tennessee Motor Vehicle Commission. The purpose of today's meeting is to review a series of complaints lodged against several dealers that were both excessive in number and egregious. As such, staff felt it prudent to have the full commission review and consider these complaints along with legal counsel's suggested action. Along those lines, we will convene the full commission and forego our typical meeting of the legal committee for the initial review of the legal report. Additionally, we will forego review and adoption of the minutes from our April meeting, a report from the director on licensing activity, and we will not entertain any appeals today. All those items will be addressed during the regular quarterly meeting in July. Our sole purpose today will be to review and act upon the legal report provided by the legal counsel. And with that being said, we do have a sign-up sheet in back in case anybody's here that needs to make a comment at the end of the meeting. We can read that at the end. I guess we want to turn it over to you, Executive Director Lawrence, or do we want to let Nate still do the legal?
Well, we're not having a legal committee.
Okay.
So this is for the full commission. And I had, Chairman Jackson and I had discussed that.
Okay.
And so he was aware of that.
Carry on.
I will call the roll now for this specially called meeting of the Motor Vehicle Commission. Commissioner Andrews is present. Commissioner Barker is absent. Commissioner Copenhaver is absent. Commissioner Elam is present. Commissioner Galvin
Here.
is present. Commissioner Jackson
Here.
is present. Commissioner Kramer, Commissioner Levy is present. Commissioner Melton
Here.
is
Here.
present remotely. Commissioner Norton
Present.
is present. Commissioner Speaker
Here.
is present. Commissioner Vaughn
Present.
is present. And Chairman Roberts
President.
is present. Mr. Chairman, you have a quorum.
Okay. Good. All right, the meeting notice was sent out, and do we have to, okay, I'll turn it back over to you.
I'll go ahead and read the meeting
Okay.
notice. This meeting's date, time, and location have been noticed on the Tennessee Motor Vehicle Commission's website, included as part of this year's meeting calendar since May 14th, 2024. Additionally, the agenda for this month's meeting has been posted on our website since May 14th, 2024. This meeting has also been noticed on the tn.gov website.
Okay, do we have, we need to adopt the agenda for today's meeting. What's your
Commissioner
pleasure?
Jackson, motion to adopt the agenda.
Okay. Okay. Any further discussion? All those in favor say aye. Aye. Opposed? Okay,
You have adopted the agenda via voice vote.
okay. We're going to turn it over to Erica or yourself. We're going to take one legal case each. Is that what we're going to do? And just kind of give us why that one's here?
Well, I think if it's okay with you, Chairman, I was just going to kind of summarize why most
Good.
of these are here and why we
I like
are
that.
here today.
Okay.
So we wanted to isolate these cases due to the large number of complaints that were filed against some of these dealerships. You'll see that if you've reviewed it. And in some cases, the egregiousness of the respondents' actions. So legal staff and commission staff made the determination that most of these cases deserve a more comprehensive review by the full commission due to the severity of some of these violations, as well as just the complicated facts. And we seem to get all of these at once. And it's very unique to have such a large number of complaints filed against single dealerships. So we just thought it best to isolate them, and if the commission wanted to talk about them, we'd have it on this single report instead of a report with hundreds of other complaints. They seem to go together.
And if you don't mind, I'll interrupt real quickly because I see we've actually had several other commissioners join us remotely. So for the record, Commissioner Copenhaver and Commissioner West, is that you?
That's me.
Okay. And Commissioner West has joined us. So Commissioner Melton, those three are participating remotely. We may hear from Commissioner Kramer, but I'm not sure. So we'll keep an eye on that.
So with these, Chairman, would you like for us to kind of summarize each one or read them? Since it's a short report? Okay, just, and then we can. And then we can go through questions once we're done with our summary of each one.
Don't forget to turn your mics on.
Yes, okay. That's your job today.
Okay, so,
Hit me.
okay.
Okay, I'll start with the first complaint, which was mine. And there are 5 complaints associated with this one. Each of these complaints were filed against a respondent referring to title issues. Each complainant alleged basically there were extreme delays in obtaining their titles and or registration documentation from respondent. At first, we had some issues getting a response from respondent. So we sent out an investigator. They went out there and they noted that the lot in the dealership looked empty and that the licensing division received a 60-day termination notice on 1/3/2024 from the manufacturer that the franchisee agreement with respondent was terminated. So respondent then did get back to us and they explained that their attorney is in constant communication with the bank as they're closing and attempt to get these these respondents their titles and their information. So basically, due to their response and due to the fact that they're closing, what we were recommending was either assessing just trying to make sure I had the right recommendation, assessing a $1,250 civil penalty, which would be $250 per 5 violations, or offering them the alternative to voluntarily surrender their license since they're still active technically until November 30th, 2024.
This is Commissioner Levy. I had one question on that as it relates to, I think, several that we're going to talk about today where you're going to be offering that option. Is there a reason, because the violations occurred, they're going to be closing, they're going to be turning in their license anyway? Is that just to get the leverage to try to get the matter closed out, or is there not a reason we would still want to receive the penalty funds to discourage this type of activity in the future?
Yeah, so we went back and forth on that quite a bit if we wanted to just do the civil penalty, even though they are closing technically, or if we wanted to give that option. And it was kind of something we wanted to hear what you guys' thoughts on, if we want to have the option of, because typically we do just close and flag these if they are closed, but since these were so egregious and so many of them, we also wanted the option of a civil penalty. So we kind of want to see what your guys' thoughts are, if you wanted to offer the alternative or if you wanted to just pursue the civil penalty.
Thank you. Can you give the rest of the commission members our choices, like you can increase it?
Yes,
you can
yes,
keep
yeah.
it the same?
So basically, you have the power to increase the civil penalty per violation per day for $5,000. So right now, we're doing $250 per violation within this first one, but you do have the power to go up to $5,000 per violation per day. And you have the availability to lower that to just about as low as you want. We're going off the agreed citation, which I think Erica gave you, which is something that was previously created to kind of just give a basis of this is where we do for the first offense, second offense, third offense. Sorry, just received a message. And so you have the availability to do that. You also have the availability to seek for them to voluntarily surrender their license, which is this, or you can seek revocation, which they have the option to at that point accept that, or we could go to a hearing and try to revoke their license since they are technically still active until November 30th, 2024.
Commissioner Norton, I have a question. So are they closing or are they closed? Is there an update?
It's closed.
It's closed?
It's closed.
Okay, they're closed, so they're not operating?
They're closed.
Okay, that's good, because my concern would be, in our scope of the commission is to protect the consumer.
Yes.
Looks like there's consumers not protected.
This dealership does have a different location
Yeah,
with the
I see
same
that.
owner
Yeah.
that is still
Yeah.
open, so that kind of gives us a little bit more power
But they're-
with if we want to seek civil penalties.
Well, there's two separate.
Two separate
scenarios.
locations,
Totally
yes,
two
same
separate
owner, yep.
claims, nothing to do with one another.
Yep.
But the first one, if they're closed, I mean, the thing is to make the consumers whole
Mm-hmm.
any way possible with a surety bond, because they hadn't had a floor plan for a year, and they've been 60-day notice of termination by the manufacturer, that's expired. So really, there should be no question, in my opinion, of a license or no license. These people are not in business. So is it a situation where they can surrender or pay the penalties? I mean, is that the option, the only option? Or, I mean, a lot of time to me, it just needs to be shut down by virtue of them not checking the boxes to be a licensed dealer in the state of Tennessee. That should be a non-issue.
And just from an internal view to help you understand, we have closed their license in our system, or we will, no matter what, because they don't have a dealership anymore. But a lot of times when we just close and flag, these dealers might still have their dealer license, their physical one, or they're trying to do something with their license until it's fully expired. So this gives them, I think, an incentive to sign an actual consent order, whether it be paying the civil penalty or just signing a consent order that they're voluntarily surrendering their license, where they're agreeing that all of these things happen. And then we have it on the record, whereas we don't have any of that admitted to when we just close and flag. And then if they do agree and voluntarily surrender, we have that on the record, and we can deny them in the future because we have that revocation on the record. And if we don't, then we can't use that in the future if they were to try to come back and reapply. And another reason I think we are offering the option is because if they see a civil penalty and we give them the alternative of just surrendering and not having to pay, we're more likely to get them to sign something at all. Because if they're closed and they're shut down, they don't really have any sort of incentive to come and sign anything.
So the question would be, is a consent order more important than the revenue?
And I would think the getting it on the order, getting consent order, getting it signed is more important. So that I think it's fine to keep them that have that leverage of you're either paying a fine or we're closing this up with paperwork. So just was curious.
So Commissioner Levy, you're saying, let me make sure I understand. You're saying that the getting the dealership to forfeit their license is more important than getting the 1,200.
Right. I don't,
Yeah.
because I don't think it'd be worth the risk that
I
they're
agree.
then going to be fighting it out, and then we're really going through a whole process to try to get $1,250 when the real goal is to get the consent order and get the license closed out.
I think that's correct, and I think that that's the best way to take care of the consumer.
And I'd like to add, also, this is part of the discussion that we had, absolutely that we have something on file that's legal and binding. I know that Commissioner Norton says for all intents and purposes they're closed, and they are. But we do have some dealers, and we're going to encounter one later on this report, who have been closed for over a year and continue to sell vehicles. So, not everybody plays by the rules, and if we can just get something that's legally binding, I think that's helpful for us, and we have it on record going forward.
So two quick questions. One, in this, it says, it sounds like the titles are not in the customer's hands yet. It seems like they're promising to do that in a couple weeks, whatever that means.
So we've received varying updates. I believe some of them have received their title based on the information we have, and some of them have not. So
So-
and the ones that have not received it, we're being told they're working with the bank as they're closing out to try to get these people their registration and title information. We have given them all the surety bond information. And we can also refer this over to the Department of Revenue, who has a little bit more power with helping customers get their titles and registration information.
So in terms of taking care of the customers, we feel like that we've got enough teeth in this to make sure those titles do get delivered, so the customer isn't going to end up with that problem.
Yeah, so It's a little harder for us to enforce them to give them the titles as we don't have jurisdiction over that. That's the Department of Revenue, but we definitely have enough evidence on there being a violation for delay in issuing their titles. That is a violation under our statutes and rules. So that's kind of where the penalty is coming from for that. We have provided them the surety bond information, which is a typical step we take, and we can refer this over to the Department of Revenue, who hopefully can provide them more information.
Okay, and this is my first time being in something where fines are being assessed. But I know if I get a fine from a HOA, they put a lien on my house. So this commission doesn't have any kind of collateral or any kind of teeth to actually collect these fines? I mean, we have less leverage than the HOA.
Yeah, so we would
as far
send it
as
to
that?
collections eventually if it got to that point and they didn't pay.
So is there any option to
And it can stall their renewing
a
of-
$5,000 per thing fine in lieu of them providing the titles or surrendering their license? I mean, can you do the either or, protecting the customer and the other stuff, and make it so they're really
If that's something you
inspired
guys
to
wanted
do
to
it?
vote on.
So that is an option, is
Yes.
put an actual punitive fine that requires them to fulfill.
It kind of would be like this, is the option of you can pay this fine if you don't provide within 30 days, or whatever date time you guys pick, that's just an example. Within 30 days, if you don't provide proof of title delivery to the customers, then you would be assessed a $5,000 civil penalty per
And
delay.
then, if we're to put a penalty and tie it to something, what is the collateral that we're putting the lien on? Is it their property? Is it their building? Is it some
No,
other
no, no.
asset?
So what would happen, this would affect their license going forward. So let's say they sign the consent order agreeing to, we will provide the titles within 30 days, or we'll pay this $5,000 penalty, and they don't pay it. It would go to collections, and then if they ever came back and tried to reapply for their license when it expires out, or if they're trying to renew their license, that would stop them from renewing it. If they don't sign the consent order agreeing to that, it would go to a hearing, and then at that point, you guys would have the decision to decide how you want to go forward.
I got you. So in that circumstance, how hard is that to dodge? I mean, do they form a different LLC or just grab a different person to be the dealer, and they just sort of skate around it?
Essentially, yes, yeah.
Fair
That's-
enough. Okay.
Hey, Commissioner Norton, to Nelson's point, is there a pending sale for the dealership, the franchise? There is a pending transaction. Is that
Well,
some-
that's what we've been told.
Well-
That's what our investigator was told.
That would be easy, to your point. That would be something to put a lien on, that you could, to something to this effect. If we want to protect the consumer, I think that's paramount in our scope mission for the here, is to protect those titles, because I've been around a long time. I've seen how these consumers are harmed. If there's any way we can hold them accountable to make sure those get perfected. And I mean, they're obviously in dire straits financially. I mean, obviously they want to do what they want to do, but there is resource available if they do close that deal. Somebody's going to buy it. I promise you, somebody's going to buy that point. There is a deal going to be pending on the table. So if there's anything we could drag along to the effect of, okay, yeah, you can get your money when you close this deal, but you still got to take care of these people and put that up in front.
Yeah, I mean, it makes it hard when they no longer have a license and we have nothing to hold over them. But I really, from what I have heard about past cases where we've had big dealerships that have closed down, I think the Department of Revenue has always been helpful in getting consumers their titles when there's no longer an active dealership. Is that right, Denise? Because they can just issue a title, and whereas
and-
we can't.
And what we'll do, what I'll pledge to do at the conclusion of our meeting is go through and look at each one of these, and I will share those with Revenue and ask that they reach out to their particular county clerk, whichever county clerk is involved, and ask them to, at a minimum, approve a temporary operating permit. And they'll do that. We did not have the resources to continue. I mean, this is like a daily thing, to call to check and see, is there a status update? Has anything changed? And just as a reminder, I mean, when we talked about this one, and again, their franchise had been revoked, and we know they're going to close, and this is historically a well-established dealer and has had very, very few complaints. So I'm not sure what happened. I think they had some internal fraud going on with like their comptroller or something. So it is a shame. And I think we were all feeling a little sorry for them. So we assessed that penalty. Our suggestion was the $250 per violation. You guys can change that. You can, I mean, if we want to have a big stick, up to 5,000 per violation. So That might be further incentive. I hate to talk out of both sides of my mouth because I just said we have some dealers later on who continue to operate even though they don't have a license. I don't really think this one is going to
We have
be
no,
like that.
yeah, we have no proof of that. They're gone,
Yeah.
basically. We've had an investigator go out multiple times, and they are gone at this location. And we have received some updates. Like I said, it does appear that some of the complainants have received their titles, but we just are not getting clear information on that. And none of the complainants have followed back up and reached back out about any information or if they're still waiting or not. So it makes it a little bit more murky on exactly how many of them have not received and how many have. But the Department of Revenue definitely has a lot more power in helping them receive their titles.
So we think that we can trust the revenue to take care of the consumers beyond. And you think it's still important for us just to get the dealer to sign?
I think the most important thing we can do and the most helpful thing we can do for consumers in the future is to take action on the license, which would be either allowing
I
them
agree.
to surrender their license or sign this civil penalty, which would then be getting something on the record and having something legally binding to them.
Yeah.
And affecting their license status going forward.
Because every day that he's out there in limbo, he could be doing harm to someone else.
Exactly, yes.
And we need to get it shut down as soon as possible. And as much as we want to be, in the fining
Yeah.
business, it just doesn't seem like it's taking care of the consumer
Yeah.
in the short run.
And unfortunately, I wish we had more power in obtaining titles and helping consumers get issued titles, but that's just completely under the Department of Revenue.
My take, and I completely agree, to me, this is a stall tactic, he's not gonna pay this fine. I mean, the fine is very minimal. If the business is closed, they're not gonna pay it. I mean, if we could raise it to 5,000, will he pay it? Probably not. I mean, to me, then you got the attorney contacting the bank. I mean, to me, this is a stall tactic. Business is closed. We just need to take that action and
Yeah, and
voluntarily just get rid of it.
Yeah, and so right now what the recommendation is that they can pay the penalty or they can voluntarily surrender their license. So we can keep that or in there, or you guys can vote to just have it be the only option is to surrender your license or the only option is to pay a fine. So it's in your guys' hands. Right now, we were recommending you can pay this fine or you can surrender your license.
We're going to take this case by case and vote on
Yes,
it, right?
yes, yes.
So if somebody wants to put something in the form of a motion at this time, you can.
One more question.
Okay?
And I'm not able to get my mic on, I guess we've got 2 minutes.
Yeah, we have to have 3.
All right, so, you mentioned it's a minimal fine, and if we keep the or in it, because our real goal is to get the license back, do we need to make the fine big enough to get their attention, to build some urgency in doing the right thing that we want them to do, which is give their license back?
And to clarify, typically on the schedule that you guys received, under this violation, it is $500 for the first offense, but just because there were so many, we initially just came in at a lower $250, but you guys can go up to the schedule if you wanted to, or higher than that, but the schedule notes the first offense at $500 per violation. So we could be up to we could go up to 500 times 5 if we wanted to, instead of the 250 times 5.
And I think if the commission feels like even making the per violation civil penalty higher, I think there is some factors here that would allow us to go higher than the standard agreed citation schedule because there's 5.
I agree with that, yeah.
5 of them makes it more severe, therefore I think that's a fair argument to go above our standard $500 per violation. So if we wanted to do 1,000 or 2,000 or, again, all the way up to 5,000, I think we have.
But
the-
Erica, does that fine help us get him to?
That was our thought
I
process.
believe it would, yeah.
Yeah, basically, it's kind of a
I think
leverage.
that's,
If are they going to want to give in and pay, let's say we do the 5, I don't know, I'm not exactly sure what 500 times 5 is off the top of my head, but let's say we did up to that, are they going to want to pay that, or are they wanting just to surrender their license for their businesses that are
Yeah.
already closed?
They're going to see this larger amount on a consent order or the opportunity to avoid that and involuntary surrender and sign this consent order and agree that these things happened. And I think with this one in particular, more so than some of these others we'll go over today, the owner has more of an incentive because they have an open dealership right now.
At a different
And we're going
location.
to go over that one in number 2.
I would just like to add, as far as the consumer in this case or any cases moving forward, is I understand that shutting them down or denying them a license to protect future consumers, but it doesn't take away the fact that the consumers that have already been affected are basically, ultimately, they may end up getting their titles. We don't know how long that time span will take. But, you know, many times that's people's means of transportation to get to work, what they've had to go through, finding an attorney or dealing with that. So I just think a fine is, you know, I just think that's something that should definitely be considered. And maybe depending on, like you say, the degree and the number. But I don't think that just simply taking their license or closing them is not showing them, as well as any future dealers, that they need to, you know, what they've done needs to be, they need to be penalized for that.
And you do have the availability to seek voluntary surrender and a civil penalty. It doesn't have to be the or. It could be the and, the or, one or the other.
I would just say, I think, well, we have a bunch more of these to go through, and if each one takes 30 minutes.
That's right.
Whew. I mean, normally in this meeting, we don't get too deep into the weeds, and we're reviewing 180 cases, and we have comments on 9 or 10 of them. So, I mean, unless we see something egregious with what the staff has recommended, I think we could actually even wait until the end, like we normally do it, make all of the changes to them, and then vote one time on the amended legal report. So, on this one, it sounds like the only question we have is, do we want to increase from their current recommendation of $250 per activity, or not?
And do we want to keep the option to either pay
And
the
keep the option,
penalty?
right? Do we want to make any changes from the current proposal of $250 per complaint, or voluntarily surrender the license to get a consent decree?
I think the only thing we have to consider is what we do, will that benefit the consumer the most? We just have to find out what will be that resolution to it that will get us the best outcome for the consumer, because we don't want them to get stuck.
Right, and my suggestion would be, for whatever reason we gave a discount, I'd say we stick with the schedule. So increase them to $500 per, give them the option to voluntarily turn in their license, and add a note of making the referral to revenue to help the existing consumers get their title.
You want to make that in the form of a motion?
Do we, normally we
Are we
said we'll
gonna
make
do them
those
one by
changes
one?
and we'll vote all on it at once at the end.
I'm getting,
Do you want to do them that way? Because I already asked that. You said you wanted to do them one-on-one.
it is entirely
Okay.
your call.
Okay, you've got the recommendation. We can go to the next one, and then we can vote on all
Yeah,
of them
we can
at the
vote all at
end.
one. I wrote it down to
Okay.
500 times 5, which would be 2,500, or voluntarily surrender and refer to the Department of Revenue.
Good, okay.
Perfect, next one.
Next.
Okay, number 2, 2023-065-701. This is the open dealership that is owned by the same individual who owns the dealership that we just talked about. And here, we did an investigation where the respondent fully admitted that they failed to pay off a trade-in within the 30-day requirement twice for 2 separate transactions. So they also mentioned that they're under unusual circumstances with this buy-sell agreement. We've not been updated that that's gone through, but we do know that this dealership's license expires in 2 days. We know that they have not provided us with proof that they've renewed their surety bond, so we're staying on top of those things. But as of today, their license is active. They may be fully intending on renewing, and they may not. So I don't know. But we have proof of these violations, and according to the citation schedule, we normally would issue a $500 civil penalty for each one. So we have 2. So my recommendation is a $1,000 civil penalty, or the alternative that they can voluntarily surrender their license for this dealership.
Commissioner Norton, is this dealership closed as well?
No,
Still open?
but they'll be expired in 2 days if they don't do something.
So this one, it sounds like they're gonna, I would imagine they're gonna continuing to operate since it's currently open.
I would think so.
Okay.
But, you know, we haven't gotten anything that I know of for a renewal, which is pretty rare when they've got 2 days.
It expires in 2 days.
Right, which is different than the first one, because that one's active
That's
until
right.
November.
That's
This
right.
one, they truly can't do anything. They can't issue tip tags. They can't do anything in 2 days.
Okay.
So it sounds like they would be motivated to pay this fine.
I would think so, especially if they're going to renew. Like, you know, again, they could be submitting their paperwork at midnight in less than 48 hours. So
Well, and keep in mind too, just because a license has expired.
They have a grace.
You guys are very generous with a grace period. They have a 90-day grace period within which to renew the license. So I don't think it's really that imperative. I mean, I fully expect them to renew.
Or if they're involved in a buy-sell, then, I mean, then that'll wrap up.
Is this one involved in the buy-sell as well? Both of them are?
Yeah, but this is the one that's involved in the buy-sell, isn't that right?
Yes.
The first one is as well.
And this one, you're using the standard first offense, $500 recommendation. Okay. I don't see any reason to change. from the
We're
recommendation.
happy with this outcome of,
I make a motion, we keep the same penalty, $1,000 to this.
well, we're going to take it up at the end and vote them all
Okay,
at the
okay.
same time.
I mean,
But remain the same, just so we can write it down, just so that we can
Yeah,
review
we
it.
just need to write it down.
Okay.
all right, good.
Number 3, 4, and 5 are all the same owner of a dealership at different locations. So they're all having the same, essentially the same issue, except for a few of them, which I pulled out. But all of the ones under 4 are just, again, issue due to delay in, I'm on number 3, yeah. I'm sorry, number 3, not number 4. Each of the ones under number 3 are an issue with delay in title and registration. This dealership location is closed, but technically their license is still active. So again, it's, yeah, sorry. So each of this dealership's location is closed. However, their license is still active. So again, we did the 250. And the reason we discussed the 250, we went back and forth about this a lot, is just because there's so many of them within the same owner under 3, 4, and 5. We didn't want to go 500 times 70 without talking to you guys, basically, essentially is what it would have added up against for one person. So that's just kind of where we came in at the 250 to see what you guys thought about what the base penalty should be. And we also, again, recommended the option for them to voluntarily surrender their license.
Let's confirm they are closed, right?
This location is closed, yes.
And I would add that this, like, I don't know if we were having a brain cramp when we were doing
No,
this.
I just explained it because there were 70 of them
Okay.
total
Oh,
under this
that's right.
dealership. We didn't want to do 500 times 70
Okay,
without.
so that, I'm
speaking with
sorry.
them first.
So that's completely your call if you
Yeah,
want to
if we
increase
want to
that
up it,
500.
that's within the schedule. We just didn't want to come in that high since 3, 4, and 5 are under the same owner technically, and so it would have been a fine against the same person without discussing with you first, but that's completely within the schedule to go up to 500 per, and then offer, if you want to keep the offer of voluntarily surrendering their license.
Well, once again, if the goal is to get them to surrender their license.
Yes.
I wouldn't reduce from the first
Yep.
offense fine. It might be a giant number, but there's a giant number of complaints.
Okay, yeah, so we can go up, so right now we're just talking about 3, like I said, 3, 4, and 5 are technically the same person, but this is, one license number is under 3. So do you want me to go ahead and just up them each to 500 under 3?
That'd be my
I think
recommendation.
so.
Yeah, that's what he wants, yeah.
That would ensure a better outcome.
And stays consistent with the first one.
Okay, so then we can kind of just touch base on that for 4 and 5. I'll just up them up to 500 as well.
So it's the exact same circumstances? 4 and 5?
There are, under 4, it's all the same, and then under 5, there are 2 that are separate that I pulled out, that I'll just talk about those 2, but the majority under 5 are the same, that I'll up to 500 per. It's 500, for 5, it would be 500 times 27.
Okay.
I'm just going to write that down real quick before I get into the other 2 under 5.
Yep.
So have any of these individuals received their titles and registrations?
Some of them have, but it was extreme delay. The ones that have had was over a year. It's a mixture, again, of some have, some haven't. Some complainants are keeping up with us and responding, some aren't.
So same adding reference to working with.
The Department of Revenue, yeah.
Okay.
And yeah, just to clarify also, this dealership is being currently investigated by the district attorney's office in law enforcement, and we've been involved with them as well throughout their investigation. So they are also taking a different route with kind of these people that were harmed by this dealership as well. So there is that recourse happening as well.
So we got our recommendation down for number 3.
Yes, it is. We're going to up it to 500
Okay.
per delay, and then refer to Department of Revenue and offer the alternative to voluntarily surrender their license.
Number 4,
And that is kind of the same scenario. I'll up those up to 500, add Department of Revenue, and also keep the offer to surrender their license and substitution. And then 5, the first.
Well, just keep them consistent. Yeah.
Yep. And then 5, the first 27 are the exact same. I'll change those to 500, prefer Department of Revenue, and also offer the option to surrender their license. The next two there are 2 under 5 that I kind of pulled out that are a little bit different, which is 2024-010131. We didn't find any violation within that. That was kind of a warranty issue where we didn't have any evidence of a violation, so that one was recommended as closed. And 2024-015631, this was another one where we didn't have any violations found, so we recommended close on that one.
So this is the same individual, 3 different licenses, 3 different locations?
Yes, and 2 of them are closed, 1 is still open and operating.
Do you see any need to monitor on some of those closures so they don't pop back up?
So we'll have on if they agree to voluntarily surrender their license, we'll have that on record of them signing the consent order, and that will be something if they ever try to reapply that we have on record that we could bar them from reapplying.
Very good.
So I have a question on the one that's to remain open. I mean, we're asking for him to surrender his license. What if he pays the fine, keeps that going? Do we want this guy still out there operating?
Yeah, that's the question. So hopefully with the number 5 is the one that is still open and operating. So that's the 27. So that would be quite a penalty. So hopefully they're willing to just surrender their license on that one.
Well, we say we're hoping that they should.
Yeah, we can take out the penalty and just seek voluntary
Why don't we
surrender.
recommend that we take out the license?
Yeah.
Yeah, I think
I mean, 2 out of 3 are closed anyway, and I see a pattern going on right here.
Yeah, that's what I was going to say.
I mean,
Or do we need to stay consistent? I mean, is there something?
No, we don't have to. The reason the other 2, they are closed technically. So, I mean, that could be one reason why you keep that in there as an option. If they're closed right now, they're just kind of formality to give up their license. But the one that is open, we could forgo the penalty and just seek voluntary surrender since they are technically still open.
Can we get a picture of this guy as far this dealer, as far as history? Is there any previous complaints? I mean, what are we looking at, a bad actor, I guess, what I'm asking?
Sure.
Well, I sort of obsessed on this, and everybody got mad at me, but we were looking at this guy. We knew the DA was doing some investigation on their own, and I knew they had multiple locations in the same place. And so I went to pull his salesman license, and he is an actively licensed salesperson, and the address that's listed on his salesperson license looked familiar to me, so we queried that address in our system, and a whole nother dealership comes up, allegedly not connected to him at all. But that's where his salesman license is located, in the same satellite city in a completely different dealer's name.
So is the sublease situation somebody, who owns the property? Don't know? Okay.
Well, that being the case, especially he's under investigation, and he looks like a bad actor, in my opinion. I mean, I think we asked for to surrender, and if not, we revoke his license. I don't think we play with this guy.
Yeah, so number 5, the one that's still open, do you want me to go ahead and just change that to just seeking voluntary surrender? And if they don't, then we'll go to a hearing.
absolutely.
Y'all okay with that?
Fine, perfect.
I think that's good.
And then the other 2 are just closed under 5 because there are no violations in those.
Okay, number 6, we have 5 complaints. And I'm just going to review them really quick before I summarize. Okay, so the first one, we have proof that the respondent issued 3 temporary tags, or I'm sorry, 1 temporary tag more than they're allowed to 3 different times.
1,500.
And that encompasses the next 2 complaints, and then, let's see.
Shouldn't it be $2,000 for complaints, $500?
It'd be 1,500 if you had 3
Yeah, we
extra.
only had proof that they issued more temporary tags than allowed 3 times. And I think that the other one, I didn't issue a civil penalty because it wasn't more than 120 days. And all of these complainants have their titles now.
I got you. So 4 complaints, only 3 of which were
Correct.
beyond the time frame, so $1,500.
Correct. And then with this one, this is another instance where the dealership has shut down, but their license technically doesn't expire until June of next year. So I thought we would offer them the same option to voluntarily surrender their license instead of paying the fine. Right. Correct. There's no history of any discipline. And they've been licensed since 2017. And they have, like I said, they've provided the title to every complainant here. Okay, number 7 involves 3 complaints. This is another instance of a dealership that is closed, but their license does not expire till January of 2025. Let's see. So in summary of the 3 complaints involved here, I recommend issuing a $500 civil penalty for each of the following violations. 1, they failed to produce business records for our investigation, just really didn't cooperate. They practiced fraud in the conduct of business. 2 instances of failing to produce a title, and then also no longer having an established place of business, and then failure to provide proof of a consignment agreement for the vehicle at issue in complaint 2024-003-681. And I used all of these, or I mentioned all of these violations, and I think they're important is because this respondent seems to is still trying to use their dealer license. So I think it is really important to have them hopefully turn that over. So my recommendation is to assess a $3,000 civil penalty for all of those violations and then give them the option to voluntarily surrender that license. That way we can, they can't issue temp tags, they can't go to the clerk, these things that they're trying to do. And they've been really evasive as well.
So they can't make it worse.
Correct.
Good.
So their option is pay the fines and keep operating? Erica, so they can pay the fines and keep operating if they choose to?
Well,
Let me repeat that. So they can pay the fines and keep operating their business, selling cars? Is that okay? Is that what we want them to do?
well, I guess that's a really good point. We would still close out their license. So I guess,
It isn't, that's what we always do.
I mean, yeah, that's,
We
I
always
think
use
you
Yeah.
assess
and they
this
continue to
one,
operate.
you assess it and close them.
Well, that goes against what we did on the
I
does.
I do think that would definitely, this person is not going to pay this fine.
Well,
But
There you go.
I thought that would be, with this individual in particular, based on their history and how they've handled investigations, I thought this would be kind of the only incentive to get them to sign anything.
I think we need to stay consistent and go with that.
Agreed.
And it gives us some leverage with the clerk. We can let the clerk know that we've done something, because they were very frustrated to continually get these, applications for title from somebody that was really closed.
Let me ask you a question. Our mission is to protect the consumer. You make a good school teacher. So our goal is to protect the consumer. Is this a dealer that needs to stay in business in the state of Tennessee, or we need to protect the people of Tennessee? I think on this one, it looks like to me, especially he's not participating, I think we give him an option to surrender, or we look at revoking this guy's license. I mean, is that too harsh? Is that too harsh? Okay.
I don't think so, because he's not participating. The investigators, he didn't give any information to them. He basically ran them out, so.
Sandra, you work with the people
I
in the
agree.
clerk's office. You know what you're dealing with these people, and that's our job, is to protect the people. I mean, that's what we serve in this capacity. And if we're saying that this guy's not a good operator, and we don't think he's going to be going forward, then I don't think he deserves the privilege to sell cars in the state of Tennessee.
I agree.
Yeah, and while it have some value to being consistent, I think every situation stands on its own, which is why we convene to talk about them. So if this is someone egregious, I don't have any trouble at all finding him more, having a harsher penalty, or if it's a bad actor that's being intentionally evasive, I think there needs to be a consequence.
Does it make it harder for you, though, when there's no option? I mean, if we were to just move to revoke, then their only recourse is to fight that revocation?
Right,
Versus you
or-
coming in there with the carrot.
Or they just don't even, they're closed, so they don't do anything. They just ignore us. But I felt like if there was a civil penalty on the table and we made it clear we were going to go after them, if they don't pay it, unless they hand over their license and sign this consent order and admit to these violations, then that would give them the incentive to actually cooperate.
So it's more
like a
beneficial
tactic,
for
kind
you
of.
to have
Yeah.
the civil penalty there rather than just a revocation.
I believe so.
So then,
I agree.
okay.
But if they don't accept?
Need to be persuasive and get their attention.
Well, for this one, based on their past history, she thinks that $3,000 will be sufficient to get his attention, or her attention.
Well, she just said that she don't think she'll pay any.
That's what we're saying.
Yeah, so.
Well,
That's what we hope.
I'm going to disagree. I'm going to disagree because, let me tell you something, I'm a bad actor. $3,000 is not going to deter me if I want to keep operating. I think the options are no options.
Well, they don't have a dealership to operate out of. I mean, they have nothing. They're just, I don't know if they're talking to friends or using Facebook or.
So they're basically out of business now.
Yeah, they're out of business.
And you just want to make sure they don't go back in and somehow try to.
I want something on the record, so if this person's name ever comes across our desk again with an application, we can deny them.
Which is why they like the
Well,
option of having the fine, because if it's just a revocation, they ignore them, and it pops up, and they've got no way to paperwork close it out. If they're still going to be chasing after them to get their $3,000, then they're motivated to sign. That's why we want to keep it in there rather than just issuing a revocation.
And I'm okay with that, but I just heard you say you didn't think this guy was going to go away. You thought he might try to continue to operate. You said on the front end we were discussing it.
No, I mean, if we didn't, like, if they still had that dealer license technically not expired yet, but if it's revoked, then we can fully notify all the clerks that it's been revoked, and then we have it on the record as well. And they can't issue temporary tags.
Okay. All right. We're settled on that one.
Okay, yes, number 8. Let's see, this is an instance where a complainant purchased a vehicle from respondent in 2020, and respondent allegedly never delivered that title or registration. The complainant filed a claim with surety bond, but that was denied according to the complainant. So this dealership is closed. Their license isn't technically expired, but we haven't been able to track this respondent down. However, let's see. Yeah, okay. So this one is closed because the owner passed away in April of 2023. I wanted to close this particular complaint because the dealership, the owner hasn't done anything, well, the owner's passed away now, but I wanted to close this complaint and just refer it to the Department of Revenue to hopefully assist this complainant with getting their title. But number 9 is related to number 8 because the son of the owner of the dealership is trying to use that dealership license to continue to sell vehicles. So I just wanted to close this single complaint, but move forward with trying to stop the owner's son from continuing to operate this dealership.
Does the
Which will
owner's
take
son
me to
have a
number 9.
You
salesman's
want to try
license
to leave
too?
about 12? Wait a minute. I gotta, what?
Debbie, you're on, we can hear you.
Oh, I'm sorry.
Okay, sorry, what,
It was about the owner's son. I can't remember now. Yeah, does he have a salesman's license? Does the son?
no.
And he's doing these transactions
Right,
himself.
right. So with number 8, this was a vehicle that was sold prior to the death of the owner. Therefore, the only thing we can kind of do with this one is refer it to the Department of Revenue. Denise can make that single, contact with her contact over there. But I'd like to pursue the son's unlicensed activity, and that would take me into number 9. So just to give you a little
Okay.
understanding of why I would like to close and flag this single one, because it's the only purchase that was made before the death of the owner.
Gotcha. I think that's okay. What do y'all think? Okay. Now, number 9.
Right.
Go ahead into it.
So number 9, we have 2 complaints, and this is involving the son of the owner who is deceased. And we received some information from the county clerk, just letting us know that this owner's son was coming in, trying to register vehicles. It appeared that they were still trying to operate the dealership, even though the location of the building where the dealership was operating is closed. There's no cars there. There's no vehicles that have signs that they're for sale. However, there's a travel trailer right next to it that still has the sign of the dealership with the dealership's name. Now, this individual has been evading our investigator. However, we have plenty of proof through just the documentation that the clerk has provided us that they're still selling cars and they're still trying to register them. So we don't have any sort of license to ask to be voluntarily surrendered here. This is just a plain case of unlicensed activity by an individual. So my recommendation here was a $3,500 civil penalty for that unlicensed activity for each of the vehicles that we have proof that were sold after the owner's death.
Shouldn't it be a second offense, though, since he already signed an agreed citation, paying a $500 civil penalty in February?
Well, that agreed citation was just signed this year already, literally within, I guess, days of our investigation into this. So I guess we could consider that. Do you have any comments on that, Denise?
So I guess I'm asking, are any of these complaints after the civil?
Well, all of the sales were before that agreed citation, after the death, but before they were kind of put on notice that, hey, we're looking at you.
Okay, so
Okay.
they're not technically
Hey,
second.
I'm going to comment.
Okay.
All of the sales allegedly occurred in 2023. However, I think that is highly suspect because the clerk, why would you sell a vehicle in June of 2023 and that's on your title paperwork and bring it to the clerk to be registered in March of 2024? That makes no sense to me. These are the 7 transactions that we can actually pinpoint. The agreed citation that this gentleman paid and signed was issued after an anonymous complaint was filed in January, about which none of us were made aware. And so our complaints division automatically generates, they send out someone, he documented, evidently talked to this gentleman, documented there was unlicensed activity, so he fined him $500. Well, that was a get-out-of-jail-free card for him. And when I found out that that happened in March, I asked them not to do anything else, not to contact this individual. So we've had lengthy discussions about, what we could do. It is my belief, based on information from the clerk, that he's just thumbing his nose. And I mean, not just him, they also provided documentation last week for a vehicle that was allegedly sold by the grandson using the same dealer's license, which only belonged to the father/grandfather. None of these people are licensed salespeople, nor were they licensed in any way, shape, or form as, partial ownership of the dealership.
So it's the deceased dealer's license, not the son or the grandson? Okay.
Correct.
So the license and I'm gonna learn something here, been doing this a long time. So when a dealer's deceased, is that an automatic surrender of the license, or that has to be surrendered by?
I don't know how we came to know that, but someone contacted us and said, this person is deceased, and that's how we just administratively closed the license. And I think at that time, there may have been some discussions between the actual son and people on my staff, and he was like, yeah, I'm going to reapply. And he actually did put in an application for a dealership, but never followed through on it.
That was going to be my question, the obvious question in the room. I mean, if you keep getting hit in the head, let's fix the symptom. Let's go to the problem. Has anybody offered this guy a solution? Let's get a dealer's license. That would
Yes,
fix him.
yes. He obviously doesn't want to go to all that trouble. And it is, in my opinion, brazen that he has the sign from the dealership that his father owned on his travel trailer. Yet, our
Brazen.
investigator could not catch him. And, I mean, the clerk and I are good friends now.
Is $3,500 enough, or should we
Well,
up it to $7,000?
Yeah, that's my question. How do we get his attention?
Well, based on the information I have about this individual, I'm not sure that anything else they would be able to pay anything more. So,
That's the goal. We want it to be higher so we ensure that he's going to forfeit.
well, there's nothing to forfeit, really,
Well-
here.
Or to get the license put in his name.
Or we want him to stop, so.
We need compliance.
So the question is $3,500 enough to get him to stop, or do we need $7,000?
I mean, I really, I don't know. It's up to the commission.
Clearly, he is aware that he is practicing without a license. He was notified, by this anonymous complaint. He was notified by the complaints division and then issued an agreed citation. And he paid the $500 fine. And so he is clearly aware that him selling vehicles is not okay. And yet he continues to bring these titles and stuff to the county clerk. And, I guess now his
So it
game
sounds
is.
like a second offense, so it should be $1,000 per.
Right, no,
situation.
we definitely have every right and ability to up the amount to $1,000, and I guess that would be $7,000 civil penalty.
That'd be my suggestion.
That's fair. We need to do that.
Seven that we know of right now. And if there's more, we can bring it back.
Yeah, I mean.
And open a new complaint.
It's difficult for the clerks too, because I'm told the way that they enter stuff is based on the VIN number of the vehicle. Not all of them maintain records of just individual dealers. This person is now on notice. They had satellite offices, and, they were kind of catching up on what was going on because this person was going to different satellite offices. But, now I think we absolutely will know if they try to do something else. And I think if you fine this individual $7,000, perhaps that will awaken him to the need that, he's not going to get away with doing that anymore.
Is this considered curb stoning? As well? Is this considered curb stoning? Pardon?
I think for curb stoning, I think you have to have a valid license somewhere. then-
Without a license.
You have to be trying to
Without a
sell
license.
Yeah,
vehicles
he's without a license.
at a different location.
I'm looking at the list of fines to see if there's anything else we can throw at him.
It's implied you have to have a license because it specifically says off-site sales. So that's implied that you have a valid license. So yeah, I think really the only thing we can violate him for would be unlicensed activity. You know, I wish there were more. I don't understand. I don't know what he's done with these people, if he has, you know, a supply of those paper temp tags that he's still handing out instead of printing them out of Easy Tag. I don't know. So perhaps not. And when we were looking at, when we were looking at a couple of the sales, I mean, there are a couple of sales that allegedly, these two occurred in 2024. So we definitely, you know, this is this year. And these two vehicles were personally owned by this individual. And his name is on the title, sold for ridiculous amounts, like one of them was for $100 and the other one was for $1,000. And so he's, you know, paying virtually no taxes. And again, he has, I almost said the name, he has the dealership name, you know, clearly stated on each bill of sale.
And we can go up to $5,000 per sale, just to remind you of our statutory right.
I think we do everything we can do to bring this guy into compliance. I think the knockout punch, whatever it is, I mean, maximum fines, maximum effort to shut him down.
It's obvious that he paid the $500 penalty. He knows what he's doing.
Right.
Yeah. It's obvious
And if the fine is so much that this individual cannot afford to pay it, then they would have to come before you for a formal hearing, and that would really get their attention, so.
Well, what jurisdiction will we have if he's an unlicensed dealer to come before the commission?
For unlicensed activity,
So, I mean, what does that give us the ability to do?
fine them,
More?
that's it.
And then we could attach liens.
At that point, it would be a binding order from you and the administrative law judge. Right now, it's just something he has to agree to. It's just a settlement offer. So if he doesn't agree to it, basically it means nothing. As opposed to if they had to come before you, a final order is issued, that's binding now. And they're required at that point to pay it. And they don't have to agree to it, obviously.
My question to the staff and to the commission, are we there? Is that where we're at with this individual?
I think so.
If you were to ask this clerk, they would say hallelujah, yes. Because they are being bombarded.
So it would be not a fine, it would be a formal hearing. But there's so much unlicensed activity going on, our recommendation is that you come before.
You can skip the settlement offer completely and just authorize a formal hearing, and
What does he do in the
You
meantime,
will-
though? He keeps doing the same thing.
well, yeah, I mean, that kind of goes, no matter what we do, in the meantime of,
Well, not when there's an offer of, you know, you're paying $7,000.
right.
Or
And they have to have, is it 30 or 60 days notice? For a hearing?
Oh, 30.
Okay, so with, if you just authorized a formal hearing, we have to notify them 30 days prior to the hearing date. So that's kind of how fast it could happen. With a consent order, if you made an offer, they have 30 days to sign it, and then it would be 30 more days. I would set a formal hearing, and it would have to be 30 more days out from that. And that's if I stuck to that would be 60 days from the time the consent order went out. Or 30 days if you just want to go straight to a trial. And then we would
Reminder,
absolutely have
what
a
is the,
trial. And everybody,
What is
we
the
would
status of Dad's license now that he's deceased?
Dad's license was closed by us because we were notified, Commissioner West, that he was deceased. There are no notes in the file electronically that say where that information came from or who actually notified us, but it was closed April something, 20-something of 2023.
Commissioner Norton, I would advocate that we skip and go to a formal hearing on this guy. We've only asked one at a time in my tenure here to look somebody in the eyes and see what they're thinking about. Because you said another thing that concerns me more than any of it. He's facilitating tax evasion, 100%. There's no question. This is a bad character. He's thumbed the state of Tennessee, but it doesn't sound like he's scared to pay fines. So I mean that's our duty to hold this guy accountable. And so. Much as the work goes in a formal hearing, I don't see any reason. This is what we're here to protect ourselves.
Why don't we have him pay the $7,000 and have him come here to the commission in front of us, and then let us scare the heck out of him?
Yeah, can we do both?
You could authorize a settlement offer of $7,000 or whatever the amount be, and within that agreement, they agree to come before the commission.
No, not agree. You need to be here.
Well, agree.
You-
Still
yeah.
agree.
That's what I mean.
Must
We're not
agree.
allowed to kidnap anybody.
Yeah, I mean, like, you will be here, you will pay this, you're signing this consent order, admitting to all of these violations, and you will show up at the next board meeting to speak.
The
Yeah, he doesn't have a
necessity
sales
of a
license.
full-blown hearing is just, I think is out of the
Well,
question.
that's what I'm trying
'cause it's
to,
just too
if we
much
have a
money.
full-blown hearing, just know
Let us
that
tell him about the hearing. Yeah.
very soon, we will have to have a quorum, everybody will have to be here, and it will be a full trial to just possibly get a fine, which
That's
we may
right.
be able
And
to
a
get
small
with
one
the
at
consent
that.
order.
Yeah. Why don't
And
we
I'm
do
not,
that?
I'm not trying to discourage you, I just want
No.
you to know the reality of it, because it's been a long time since we've had a hearing that's not a protest.
Right.
That's right.
Are we all in agreement with that? Yes. Okay, good. All right, let's move on.
Well, she needs to know what we agreed to.
$7,000.
$7,000
And he has to
and
come to our
request that
next
they
regular meeting.
attend the next
So
quarterly meeting.
$1,000 per violation for a total $7,000.
Correct.
And you will appear at the next board meeting.
That's right.
To
Right.
talk to the commission.
Yes.
Okay.
Okay? I think that's the recommendation.
I'm going to write that
That's
down,
good.
so give me one moment, please.
Well,
Devil's advocate. What if he says no?
Now, if he says no and doesn't sign the consent order, we would have a formal hearing. Or
But-
it would be represented to be closed and flagged if you don't.
put that
Or
in
to be
writing when you
closed.
contact him. Make sure he knows that option B, if you don't come.
Oh, right, no, it's made very clear that if
Good.
you don't agree to this consent order, there'll be a formal
Well,
hearing.
why can't we just say that it's going to be flagged and closed if he doesn't show up?
You want to let him know that?
What's that?
You wanting to let him know that we would,
No, it's, I just hate for more time to keep going by. Is there any way we can speed that up if he doesn't comply? And I think he will.
speed what up?
Huh? Month and a half, he's gonna be here.
Speed which part up?
He just needs to be here in July.
Yeah, he needs to be here in July, but if,
Former hearing, and let's move on to $7,000.
I think we need to do that and just forget the rest of it.
I
think
mean,
that's
I
what
don't think
matters.
there's any statutory, and please correct me if I'm wrong, everyone here, if there's a statutory requirement that we have to give them 30 days to sign a consent order. I mean, I can say you've got 7 days to sign
Yeah,
the consent
I-
order, and if you don't, I'm going to set a formal hearing. And then we could have the formal hearing in July, while
Okay,
you're
let's
here.
do that.
Some of my other
I like
commissions,
that.
we do 10 days for them to
I
decide
just
if they
don't
want
want
to
to
accept the settlement offer or
keep
not.
kicking it down the road and having
Right.
all this.
That way you'll know y'all are already here.
That's
It'll
right.
be quick. It won't be delayed. So I'll just make sure that I calculate. Well, it just has to be the amount of time that would give them 30 days. Okay.
Okay?
So 7,000 and appear before the commission, and he has 7 days to pay.
Yes. 7 days to sign the consent order and pay. Or a formal hearing will be set, and I can go ahead and put that date in there, so
Okay.
they're put on notice.
Okay.
And then file it. Okay, number 10 is one that is an older, it really doesn't fit within the bounds of all of these other complaints. It's just an older complaint that I wanted to get on this report because we're all here today, and I'd like to get it closed, so it doesn't pass 300 days. And this is just a complaint that was administratively opened. It's another instance of a county clerk letting us know that some vehicles were being processed through their office by respondent. We did an investigation. The respondent did cooperate, admitted that they were selling vehicles, kind of said, I'm doing it for selling to my friends and family. They're from another country. They didn't understand that they needed a license. They actually quit selling when the clerk let them know that you have to have a dealer license. So that was prior to our investigator going out there. Therefore, I thought it would be probably fair to limit the civil penalty to our standard $500 civil penalty per violation, and we only have, or I guess that's why I decided to just stick with $500 for unlicensed activity in general, instead of fining them for per violation, because we've got a cooperative respondent here, somebody who's actually following the law, respecting the law. But it's up to you. We could also do more per sale of, that I have proof
Good with
of.
that.
I think we go.
Yeah, we're good with that. Yeah.
Okay, all right. Number 11.
Okay, number 11 is one that's already been presented to you. I wanted to take this opportunity to re-present it and give you some new information. And the new information is that respondent contacted me regarding the fact that their license had been expired between December 31st of 2023 and then through February 4th. They were very confused as to why their license was expired. So we went back and looked in our files and our licensing application files, and it turns out that we were just waiting on a surety bond that was active for the next 2 years, where they had only provided us with a surety bond that had a effective date for 1 year. So really in my opinion, they had everything that they needed to us, and I don't have any notes that was communicated to them in our system. And the person that would have probably done that is out on maternity leave. So I thought that here we would give them the benefit of the doubt. They were not missing anything. I don't know that anybody notified them that their license wasn't active. They had everything into us by December 29th. So my recommendation is we kind of void that civil penalty and issue a letter of instruction clearly explaining that your surety bond needs to be for the effective date of your license, which would be 2 years. Okay, now, the last one, I believe this is the last one. This is another one that's been presented to you already. We had authorized a $4,500 civil penalty for what we thought a dealership was operating with an expired surety bond for 9 months. Well, it turns out, after I spoke to the respondent, I was notified in error by our investigator that the surety bond was expired. It never was. We had gotten a notice, I believe, but they had corrected that and provided us with proof of active surety bond. However, we still have this issue of a vehicle that they sold to a complainant. It had been traded into them prior to it being sold to the complainant. And I'm just going to read this to you because it's very complicated, and I feel like I summarized it well, and I don't want to mess it up, and I want you to get all the facts. And then you can, I also thought this was a perfect case for yourselves as experts, dealers yourselves, to know if this is something that can really happen or not. So respondent notified me that, and kind of gave me more information about how they got in this spot. They are still making payments to this complainant to make them whole. This complainant still has this vehicle. But basically, the vehicle that was sold to them had been a trade-in. Respondent, the vehicle had a lien on it at that time through a third party. So once it was traded into respondent states that they never pay off any third-party loans by a singular method, but instead they use different methods of payment just in case something doesn't go as planned. Therefore, respondent paid the loan off for the trade-in vehicle to Navy Federal with two different payment methods. They said they wired $20,000 and then paid a cashier's check for $19,500. So that $20,000 and that $19,500 together would pay off that full lien. After months of waiting for the title, the respondent reached out to Navy Federal and was informed that Navy Federal saw evidence of the $20,000 wire, but it was never applied towards the loan. Respondent states that the $20,000 had been withdrawn from their account. Further, respondent was informed that Navy Federal had no record of the cashier's check ever being satisfied with them. So respondent then went to their own bank, Bank of America, to investigate this further. Bank of America found out the cashier's check was satisfied to a different account that was not affiliated with Navy Federal. After months of back and forth with the Bank of America, they were able to reverse the $19,500 amount. However, respondent tells me that the initial $20,000 wire is gone, which led him to be in this situation they're in now. I asked, okay, well, what about the previous owners of the vehicle that traded it in? And respondent tells me they're still making payments. And I said, well, have you talked to them? And respondent says, no, Navy Federal won't give me their information. So respondent tells me they've done everything that they can do. These are not things that I can prove or disprove. I can't force any bank to give me any kind of information.
Gosh,
So I am at a loss as to what to do right now, other than have I had an idea that the respondent could appear before you at the next board meeting if you had questions you wanted to ask them. But if this went to a trial, I'm not really sure how I would prove any of these things, other than the title's not been provided.
Thanks for sharing that headache with us. That's pretty
I'm
good.
sorry,
And
but, it's been
in
my headache
years,
for so
I've never
long.
seen anybody handle a payoff in that order. But let me ask you a question. Isn't that what the bond's about? Can't they get relief through the surety bond on this because they can't get a title
I think the claim was denied.
through the surety bond?
I think,
I don't know. I think that individual has a right to that title, and that's why that surety bond is provided. If he can't provide that title, the surety bond gets involved.
Why is the
Because surety
previous
bond-
owner that doesn't have the car still making payments?
I have and that is what baffles me. I can't contact them. The bank's not gonna talk to me,
Why don't we bring them in here and get more advice?
Yeah, I don't know what else. I've talked to them so many times
about
that I
learning
don't
something?
know what else to ask.
Have them come to the next meeting and try to figure it
And I
out.
thought
It's all wrong.
maybe if they were in front of you, and you as experts that you do, I don't do this sort of thing every day, where you might have questions that I don't think of.
Yeah, I've
And
never
you might
heard
be
such
able to
thing.
tell if this is the truth or not,
But no
without
hearing.
having to have a formal hearing yet.
That's right.
Well, you have two consumers harmed. The one's still making the payment, and the one can't get their title.
And we've never heard from the consumers still making the payment, which I think is odd.
There's more here than we know.
Right.
I
And we
think
still
they'll get
can
it
always-
corrected and won't come, is what they'll do. They'll figure some way
Yeah.
to get this thing, resolution to it.
So I
But-
will say, we definitely, I think it's appropriate to void that prior consent order that was just for an expired surety bond, because we had proof of that. And I thought, well, this kind of takes care of it all. It's a big fine. That's gone now. So I would like just that you could vote to void that. And then at this point, we will require them to come into the July meeting. And after that, we can decide how we want to move
That's
forward.
exactly right. I think that's what we do.
Hey, I think you're great. I think it'll be fixed because I think we're going to find out the person making the payments is somebody in that guy's family or a friend because nobody else in their right mind would do that.
So
When I heard that, I was just blown away. That kind of-
get rid of the $500 penalty
Yeah,
right now.
yeah.
Let's bring them to the next
Yeah.
meeting.
And we'll just take it up at the meeting and we'll figure it out, what we do
Like
then.
someone's throwing a load.
Okay, we've got, the full commission has seen this abbreviated legal report. Do we need to get an approval?
Maybe we can just briefly run through each of the
Okay.
changes. I'll go over mine and Erica can go over hers. So for number one, we are changing the civil penalty to $500 per violation instead of $250 per violation with the offer to voluntarily surrender and refer to the Department of Revenue. Number two is Erica.
Number two, there's no change.
Number 3, we are upping each penalty to $500 instead of $250 with the option to voluntarily surrender, and we're referring them to the Department of Revenue. And then number 4, we are also changing to $500 instead of $250 with the option to voluntarily surrender, plus refer to the Department of Revenue. And number 5, we are just seeking voluntary surrender, except for the 2 that are pulled out, which are closed.
Number 6, number 7, and number 8 have no change to the recommendation. Number 9, we are authorizing a $7,000 civil penalty and the requirement to appear at the next board meeting in July, and giving the respondent 7 days to make that decision and sign that consent order, or we will have a formal hearing in July. Number 10 and number 11, there is no change. Number 12, the recommendation is to require the respondent to appear at the July board meeting to discuss this further.
I make a motion to adopt the legal report with the changes as just summarized.
Commissioner Bond, second.
Any further discussion? Executive Director Lawrence, we call the roll for the vote.
The motion is to adopt the legal report as amended. Commissioner Levy
Aye.
votes aye. Commissioner West has left us. Commissioner Melton
Aye.
votes aye. Commissioner Elam
Aye.
votes aye. Commissioner Andrews
Aye.
votes aye. Commissioner Speaker
Aye.
votes aye. Commissioner Copenhaver
Aye.
votes aye. Commissioner Galvin
Aye.
votes aye. Commissioner Norton
Aye.
votes aye. Commissioner Vaughn
Aye.
votes aye. Commissioner Jackson
Aye.
votes aye. And Chairman Roberts
Aye.
votes aye. Might I say one thing before you let everybody go? I know that some of you were aware that there possibly might be another case on this report. This was about a guy that bought a vehicle and it ended up being stolen. And so he was still making payments on a vehicle that he didn't have. We understand that there is a settlement offer in process. So that's why that one did not appear on this report.
Okay.
Can I ask one quick question? Just curiosity. What, I used to know and I don't anymore, what is the bond, the surety bond on a used car dealer and a used car dealer to open up a business? What is the surety bond amount for?
50,000, is that not correct? Yeah, for both, either one.
Okay. And it's been that way for,
Long time.
okay. Okay. I guess my thought was kind of like, could that be, I don't know what it costs to have, is it the true amount of that bond that that dealership has to put up, or is it just a percentage? Okay, that's what I was thinking. So I was just thinking, with a lot of what goes on with a lot of the used car dealerships, the bond, I just was wondering if that had ever been considered to be a factor that could be a deterrent to people, like we say, bad actors that, you don't want to, you hate to penalize good with the bad, but sometimes it's looking at a way of finding, an option.
And I'll say that I know that several members on this commission have discussed that internally, and, whether the bond should be increased or not. I don't know if there's the will to do that, but it is very difficult to, if you've got someone who is a bad actor, like somebody on this list, and we have 50 complaints and they don't get titles, a $50,000 bond may cover, 3 vehicles. So that's just food for thought.
Yeah, in my tenure, I've
We
seen,
might refer that to a study section at some point, but we can't decide that today.
no, I've seen it tried twice. I remember when it went from 25 to 50, I think the ask was like 250, which makes it eliminates a lot of people from getting a bond. So the impact study was done by the state and determined they wouldn't raise it past the 50, because we fought hard to raise it. A lot of us did.
Okay, do we have a motion to adjourn?
Second.
Second. All those in favor say aye.
Aye.
Opposed? Better not.